All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning. Would the court officer please call the case?
Good morning, Mr. President. Good morning, Your Honors. This is a situation in the Democratic Republic of the Congo in the case of the prosecutor versus Bosco Ntaganda, case reference ICC 104-0206, and for the record, we are in open session.
Thank you. I am Judge Gocholord Kipanidze, presiding in this appeal arising from the case of the prosecutor versus Bosco Ntaganda. My fellow judges in the appeal are Judge Tomoko Akane, Judge Luz del Carmen Ibanez Carranza, Judge Salome Balungi Bosa, and Judge Erdiba Surendamdin. Prior to asking to the parties to introduce themselves, I note for the record that the appeals chamber was informed that two counsel for the defense wished to attend this hearing remotely and that the appeals chamber decided to authorize such attendance. May I now ask the parties to introduce themselves for the record, please, starting with the defense.
Good morning, Mr. President. Good morning, Your Honours, and to colleagues around the courtroom. Appearing today on behalf of Mr. Bosco Ntaganda is lead counsel Stéphane Bourgon, appearing via video link. Legal assistant Benjamin Willam, also appearing via video link. And myself, Kate Gibson, associate counsel here in The Hague. Thank you.
Thank you.
Good morning, Mr. President. Good morning, Your Honors. The victims of the attacks are represented today by Amina Merush, just behind me, and on my right, Anne Grabowski, Fiona Lau, and myself, Dmitry Suprun. Thank you.
Thank you.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par Anna Peña et par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Je voudrais vous remercier.
Good morning, Mr. President. Representing the Trust Fund for Victims today are the legal advisor, Mrs. Franziska Eckelmans, assistant legal officers, Mrs. Veena Suresh and Nicole Stark-Richter, visiting professional Maria Emilia Gelmi, and myself, Deborah Ruiz Verduzco, Executive Director of the Trust Fund for Victims.
Thank you very much. For the record, I know that Mr. Ntaganda is appearing remotely. The appeals chamber is today delivering its judgment in the appeals filed by the defense and one of the two groups of victims in this case, to whom I shall refer as Victims Group 2, against the decision of Trial Chamber 2 of 14 July 2023, entitled Addendum to the Reparations Order of 8 March 2021, ICC-01/04-02/06-2659. I shall refer to the decision as the impugned decision. This is a non-authoritative summary of the appeal chamber's written judgment in the appeal. The written judgment, together with a separate opinion of Judge Ibanez Carranza that is appended to it, will be notified after this hearing. On 8 March 2021, the trial chamber issued an order for reparations, which I shall refer to as the 2021 reparations order. That order was subsequently appealed. On appeal, it was partially reversed and remanded to the trial chamber by what I shall refer to as the 2022 appeals chamber judgment on 12 September 2022. Thereafter, on 14 July 2023, the trial chamber issued the impugned decision to address the issues on remand. This appeals chamber judgment concerns appeals filed against the decision by the defense, which raises 13 grounds of appeal, and by Victims Group 2, who raise 3 grounds of appeal. Today, appeals chamber's judgment is unanimous. For reasons that I shall proceed to outline, the appeals chamber rules that the impugned decision is amended to the extent that it should be read as incorporating paragraphs 185, 186 of the first decision on the Trust Fund for Victims Draft Implementation Plan for Reparations. ICC-01/04-02/06-2860 read. Save as aforesaid, the impugned decision is confirmed. Ground of appeal 1, alleged error in issuing the impugned decision. Under its first ground of appeal, the defense admits that in issuing the impugned decision, the trial chamber erred in law and procedure by failing to comply with the direction of the appeals chamber that it should issue a new order for reparations. For the reasons that I shall outline, the appeals chamber does not find any error in this regard. For the reason that Judge Ibanez Carranza will later outline, she disagrees and finds that the trial chamber erred in issuing an addendum as opposed to a new order for reparations. The defense alleges that the trial chamber committed an overarching error in deciding that the 2021 reparations order remained in force despite the terms of the 2022 appeals chamber judgment, and that the impugned decision shall be considered an integral part of and read in conjunction with it and be understood as complementing and replacing therefrom only the specific issues with which it dealt. However, the appeals chamber observes that 2021 reparations order was only partially reversed by the 2022 appeals chamber judgment. Parts of 2021 reparations order that were not reversed remained unaffected by the judgment. Furthermore, the trial chamber, during the course of the impugned decision, also made specific reference to parts of the 2021 reparations order that remained valid. Furthermore, the appeals chamber notes that the references in the 2022 appeals chamber judgment to the issuance of a new order for reparations must be seen in context. First, the appeals chamber directed the trial chamber to issue a new order for reparations, taking into account the terms of this judgment. Those terms necessarily included the fact that this was a partial reversal in which 5 specific issues were remanded. Second, the appeals chamber stated that the new decision that the trial chamber was directed to issue would, in essence, constitute a new order for reparations, thereby making clear that the new decision was to be treated as an order for reparations, so as to safeguard each party's right to appeal the new decision under Article 82(4) of the statute. Third, the appeals chamber granted the trial chamber additional directions and discretion in relation to how it would conduct its proceedings further to the 2022 appeals chamber judgment, referring, among other things, to ensuring that the reparation process can continue as expeditiously as possible, and to the objective at that stage of the proceeding being to correct the errors identified in a manner that causes minimum disruption to the overall reparation process. Against the above background, the trial chamber exercised its discretion in a manner that was not inconsistent with the directions of the appeals chamber. The appeals chamber observes that, in principle, all the essential elements required to make up an order for reparations should be contained in a singular, unified document. That is the ordinary and preferable course. However, there is no legal prohibition on having those elements contained in more than one document, particularly in circumstances such as the present case in which there has been a partial reversal. It is also noted that by issuing a new decision dealing only with the specific matters referred to it, the subject matter of the new appeal thereafter is appropriately and clearly limited to the specific matters that had been remanded for reconsideration, rather than potentially opening up for appeal matters contained within the initial order for reparations that were final. The appeals chamber finds that the mere fact that all of the essential elements of the order for reparations in the present case were contained in more than one document is not in itself a reason to find that the trial chamber erred by proceeding as it did. The appeals chamber therefore turns to the arguments that the defense raises about the prejudice that it avers was caused by the issuance of the impugned decision. The appeals chamber finds, with Judge Ibanez Carranza disagreeing on this point, that the defense has failed to substantiate that any prejudice has been caused. Importantly, there is no doubt that the trial chamber complied with the directions of the appeals chamber to reconsider those issues that were reversed in the 2022 appeals chamber judgment. In that context, it is recalled that the impugned decision, over 157 pages, addresses each of the issues that the appeals chamber remanded. There is also, among other things, a 561-page confidential annex, which comprises the trial chamber's findings on the 171 victims in the sample, which the trial chamber obtained and ruled upon in compliance with the direction of the appeals chamber. Indeed, it is of note that the defense, in this ground, is not alleging that the trial chamber did not, in substance, address the appeals chamber had remanded to it. Furthermore, the defense has failed to substantiate that any substantive finding in the impugned decision would have been different had it been placed within the defense terms a new order for reparations. It has also not substantiated that there are specific parts of the 2021 reparations order or the impugned decision that are clearly contradictory or impossible to understand when read together. Indeed, in arguing that prejudice was caused by the issuance of the impugned decision, the defense gives few examples of specific prejudice. The appeals chamber is unpersuaded by those occasions on which the defense is more specific. For the reasons that Judge Ibanez Carranza will outline, she concludes that these did not have any material effect. The appeals chamber, therefore, unanimously rejects the defense's first ground of appeal. Ground of appeal 2, the validity of the initial draft implementation plan. Under its second ground of appeal, the defense submits that the prejudice from the failure to issue a new order for reparations is compounded by the trial chamber's error in finding that the initial draft implementation plan remained fully operational and unaffected by the 2022 Appeals Chamber judgment. For the reasons that are set out in more detail in the judgment, the validity of the initial draft implementation plan was neither addressed in nor constituted one of the issues remanded to the trial chamber by the 2022 Appeals Chamber judgment. It is for that reason that its validity is not considered in the impugned decision, does not arise out of it, and cannot be raised in this appeal. The appeals chamber, therefore, dismisses in limine the defense's second ground of appeal. Judge Ibanez Carranza respectfully disagrees that this ground of appeal should be dismissed in limine. She observes that there is an inherent link between the effect of the 2022 Appeals Chamber judgment upon the 2021 Reparations Order, which was addressed in the impugned decision, and upon the initial draft implementation plan. She, therefore, considers it appropriate to address this ground on its merits. Judge Ibanez Carranza would reject this ground on its merits. In her view, the initial draft implementation plan did not automatically become invalid as a result of partial reversal of the 2021 reparations order. She finds that it was not an abuse of the discretion of the trial chamber to have proceeded on the basis that it remained operational so as to meet the most urgent needs of vulnerable victims while taking into account the 2022 Appeals Chamber judgment in determining how to proceed. Judge Ibanez Carranza further finds that in any event, the defense has failed to demonstrate the material effect of any alleged error. Ground of appeal 3. Under its third ground of appeal, the defense submits that the trial chamber erred by not including in the impugned decision elements of the procedure for the eligibility assessment. The elements of the procedure for the eligibility assessment were contained in what I shall refer to as first decision on implementation, which was issued subsequently to the impugned decision. The trial chamber, therefore, did not follow the direction of the appeals chamber in the 2022 Appeals Chamber judgment to include this in the future order for reparations. The appeals chamber, therefore, finds that the trial chamber erred and that the errors materially affected the impugned decision. By way of relief, the appeals chamber deems it appropriate to amend the impugned decision so that paragraphs 185 and 186 of the first decision on implementation, which set out the relevant procedure, should be read to be incorporated within the impugned decision. The appeals chamber further finds that the defense additional arguments under this ground of appeal that relate to information included in the updated draft implementation plan at the time that it was ruled upon the first decision on implementation or its alleged inability to file observations on the updated draft implementation plan after the impugned decision was issued do not arise out of the impugned decision, but relate to matters that post-dated. The defense arguments under this part of its third ground of appeal are therefore dismissed in limine. Ground of appeal 4. Under its fourth ground of appeal, the defense submits that the trial chamber erred by, amongst other things, setting out criteria for the eligibility assessment that are not appropriate or otherwise not suitable for the purpose. For instance, the defense challenges the trial chamber's adoption of the criterion of sufficiently close in time for the assessment of whether the dates of events resulting in the harm suffered by victims correspond to the time frame specified in the charges. The appeals chamber notes that the trial chamber relied in this regard on its previous findings concerning the time elapsed since the relevant events took place, as well as likely impact of the events on the witness's ability to remember specific dates. The trial chamber decided to make its assessment on a case-by-case basis, taking into account the victim's personal circumstances in light of all aspects of the victim's dossiers. The appeals chamber, therefore, rejects the defense arguments with respect to the sufficiently close in time criterion. The defense also challenges the trial chamber's findings that once a person demonstrates his or her status as a victim and harm to that person is presumed or established, the causal link is also established. In that context, the trial chamber clearly indicated that victims eligible for reparations must provide sufficient proof of the causal link between the crime and the harm. The trial chamber also addressed the issue of potential breaks in the chain of causation. The appeals chamber therefore rejected defense arguments regarding the causal link. The appeals chamber also rejects the defense other arguments under the fourth ground of appeal and therefore reject the entire ground. Ground of Appeal 5. Under its fifth ground of appeal, the defense divides its submissions into two categories of error, which the appeals chamber considers in turn. First, the defense avers that the finding in the impugned decision that the defense had received the victim's dossiers with appropriate redactions and had had the opportunity to make meaningful submissions on them was incorrect. The appeals chamber finds that the defense has not established any of the 6 specific errors that it alleges in relation to the rejection of a defense request for reductions to be lifted in a decision leading up to the impugned decision. The appeals chamber further finds that the defense has not substantiated its broad assertion that the trial chamber erred in holding that it was able to make meaningful submissions notwithstanding the reductions, observing, amongst other things, that it made extensive submissions on the sample of victims in a 19th page filing accompanied by a 171-page confidential annex containing its submissions on a victim-by-victim basis. Second, the defense admits that the trial chamber erred by dismissing the defense request for the disclosure of information in the possession of what I shall call the TFV, namely the Trust Fund for Victims. The appeals chamber finds that the defense has not demonstrated that there was anything unreasonable about the trial chamber relying upon the victims' dossiers, supplemented by the submissions and additional information provided by their legal representatives. The appeals chamber underlines that the trial chamber expressly noted that the defense had access to all relevant information upon which the trial chamber relied in ruling upon the sample, albeit in redacted form. The defense has not substantiated on appeal that it was necessary for it to be provided with any further information to be able to make submissions on the eligibility of the victims for reparations. The Appeals Chamber further finds that the trial chamber's purpose in ruling upon the victims' dossiers in the impugned decision was to determine whether they were eligible for reparations. It was not to rule upon whether any of those potentially eligible victims had urgent needs, which was the issue that the TFV's questionnaires, which were sought by the defense, addressed. As such, the defense has not substantiated in its appeal brief why it was essential for it to have access to any questionnaires that may have been in the possession of TFV in order to be able to make meaningful submissions on the eligibility of the victims of a sample, in the sample. The Appeals Chamber finds that the defense has not established any error and rejects the defense's fifth ground of appeal. Under its sixth, seventh, and eighth grounds of appeal, the defense submits that the trial chamber failed to assess and properly reason the concept of transgenerational harm and the evidentiary criteria to prove such harm, disregarding the Appeals Chamber's directions set forth in the 2022 Appeals Chamber judgment. First, contrary to the defense contention that it was mandatory for the trial chamber to seek additional submissions from experts, the Appeals Chamber finds that it is clear from the 2022 Appeals Chamber judgment that the trial chamber had discretion over whether to request further expert evidence or to rely upon the expert evidence on the record. The Appeals Chamber also finds that the trial chamber duly considered the credibility and reliability of the expert evidence upon which it relied. Accordingly, the Appeals Chamber rejects the defense arguments in this regard. Second, the Appeals Chamber notes that the defense misrepresents the impugned decision in its submissions that the trial chamber failed to make necessary findings and or provide sufficient reasoning concerning. This scientific certainty as to the concept of transgenerational harm and whether it is appropriate to award reparations, therefore, at this court, any potential limitations to concept of transgenerational harm, whether Mr. Ntaganda could be liable to repair such harm, and its instruction that the victim should not be required to obtain psychological expertise. Therefore, the Appeals Chamber rejects these arguments of the defense. Having rejected all arguments of the defense under these grounds of appeal, the Appeals Chamber rejected the defense 6th, 7th, and 8th grounds of appeal. Under its 9th and 10th grounds of appeal, the defense generally disputes the lawfulness of new evidence being examined and new findings being made on the harm inflicted at the reparation stage that was not specified in either a conviction decision or a sentencing decision. In this regard, the defense submits that the reparations process is not a new evidential process in itself, and as such, the trial chamber is confined to the factual findings in the conviction and sentencing decision and is not permitted during the reparation process to make additional findings on the harm inflicted that were already made in the conviction and sentencing decisions. The Appeals Chamber finds that the defense is misdirected in its interpretation of the principle that in awarding reparations, a trial chamber must remain within the confines of the conviction and sentencing decisions. The Appeals Chamber considers that the conviction and sentencing decisions define the parameters of the convicted person's liability to repair the harm. Thus, in awarding reparations, a trial chamber is restricted to relying upon evidence and making factual findings on the harm that is caused by the crimes of which the person is convicted, as set out in the conviction and sentencing decisions. These limitations on the trial chamber's factual findings in defining or identifying the harm does not, however, preclude the introduction of evidence or other factual findings that were not considered for the purposes of the conviction and sentencing decisions. Against the court's legal framework, particularly Article 75(1) and Rule 94 of the rules, the Appeals Chamber finds that it is not impermissible in awarding reparations for a trial chamber to define the harms which resulted from the crimes of which the person was convicted, based upon evidence and findings that may not have been specified in either the conviction decision or the sentencing decision. Importantly, and contrary to the defense argument, the introduction of such reparation-specific evidence and factual findings during the reparation process does not expand the scope of the conviction and sentence on the basis of the lower standard of proof. Rather, in reparation proceedings, it is the harm suffered and not the crimes of which the person has been convicted that is further defined or elaborated upon. Turning to the defense more specific argument that the trial chamber erred in law by entering additional findings on the damage caused to the health center in Sayo and the affected community, thereby exceeding the scope of the conviction and sentencing decisions, the appeals chamber is not persuaded. The defense's argument is premised on the understanding that the finding in the sentencing decision, namely that the damage to the health center was unclear, amounted to a finding beyond reasonable doubt that no harm was inflicted on the health center as a result of the crime of which Mr. Ntaganda was convicted. Contrary to the defense argument, the appeals chamber remanded this matter to the trial chamber because it did not consider the relevant findings in the sentencing decision to amount to a finding beyond reasonable doubt that the health center had not been damaged. In the absence of a finding beyond reasonable doubt at the trial stage concerning the actual harm caused, the trial chamber was not precluded from establishing during the reparation stage, on the basis of all of the evidence before it, that on a balance of probabilities, the attack on the health center caused damage to the health center. Thus, the trial chamber was not prohibited from defining the harm caused at the reparation stage by making further findings based on the presentation of relevant evidence. For reasons more fully elaborated upon the judgment, the appeals chamber rejected defense 9th and 10th ground of appeal. Under its 11th ground of appeal, the defense challenges the reliability of the trial chamber's finding that the attack on the Sayo Health Center caused harm to its service provision and exacerbated the vulnerability and suffering of the civilian population. In this respect, the defense disputes the trial chamber's reliance on Dr. Gilmore's report. For reasons more fully explained in the judgment, the appeals chamber finds that the trial chamber's approach to this issue was reasonable in the circumstances. The trial chamber did not err in the exercise of its discretion when it concluded that Dr. Gilmore was credible and her report reliable. The defense arguments in this regard are therefore rejected. Furthermore, the defense takes issue with the evidence relied upon by the trial chamber for its findings in relation to whether the attack on the health center caused harm to the civilian population of Sayo and the surrounding community. In reviewing the evidence assessed by the trial chamber and its related findings, the appeals chamber notes that the trial chamber arrived at its conclusion by assessing submissions from the parties to the prosecutor, evidence already in the case record and some that had been recently obtained, and findings from the conviction decision and the sentencing decision that had been established beyond a reasonable doubt. The appeals chamber considers that the trial chamber assessed this evidence holistically and concluded on a balance of probabilities that the attack on the health center caused damage to the health center in Sayo and loss of adequate healthcare provision to the community that benefited from it. The defense argument is therefore rejected. For reasons more fully elaborated upon in the judgment, the appeals chamber rejects the defense 11th ground of appeal. Under its 12th ground of appeal, the defense submits that the trial chamber erred in law by finding the causal nexus between the harm resulting from the attack on the health center in Sayo and Mr. Ntaganda's liability was established. The defense contends that the trial chamber found that the health center had suffered harm as a result of the attack, despite the fact that the evidences relied upon did not demonstrate that this physical harm had occurred during the period of November 2002, when the attack of which Mr. Ntaganda was convicted took place, or even before 6 March 2003, when the UPC FPLC was chased from Bunia. In assessing how the trial chamber addressed causation in this respect, the appeals chamber finds no discernible error in the trial chamber's approach. Instead, the appeals chamber notes that the defense claim is unsubstantiated. The appeals chamber considers that there is no evidence on the record, nor has the defense pointed to any that demonstrates that other actors committed attacks that resulted in damage to the health center during the relevant time frame. The argument is therefore rejected. The appeals chamber therefore rejects the defense 12th ground of appeal. Under its 13th ground of appeal, the defense submits that in the context of the deteriorating and dire security situation in Ituri, the trial chamber erred by rejecting its request for measures to be taken to ensure that the implementation of reparations would adhere to the do not harm principle for the benefit of legitimate victims. In particular, the defense challenges the trial chamber's findings that the implementation of the initial draft implementation plan continues to remain generally unaffected by the security situation in Ituri. The appeals chamber finds that the issue does not arise out of the impugned decision. As correctly argued by Victims Group 2, this issue was not one of the 5 specific issues that were remanded to the trial chamber by the appeals chamber in the 2022 appeals chamber judgment. The trial chamber addressed the issue in the context of the implementation process, which was ongoing before and is continuing after the issuance of the impugned decision. As the matter was not addressed in the impugned decision, the defense cannot raise it in the context of this appeal. The 13th ground of appeal is therefore dismissed in limine. Appeal of Victims Group 2, ground of appeal 1. Under the first ground of appeal, Victims Group 2 submit that the trial chamber erred in its estimation of the number of potential beneficiaries of reparations amongst the victims of the attacks. The appeals chamber has divided the allegations into 3 categories and reject them for the following reasons. First, victims group 2 submit that the trial chamber erred in disregarding what they understood to be the most efficient and pragmatic method to estimate the number of potential beneficiaries of reparations, namely, to rely upon the population size of the 13 affected villages at the time that the crimes were committed. The appeals chamber rejects the argument raised by the victims group 2 that distinguishing between the population size and the population of the attacked villages contradicts the presumption of civilian status under international humanitarian law. The distinction between persons taking a direct part in the hostilities and those not taking part was made in the relevant section of the impugned decision for the purposes that neither concerned nor contradicted the presumption of civilian status under international humanitarian law. The appeals chamber equally rejects victim groups' arguments against the finding that most of the inhabitants had already left the relevant areas before the attacks and therefore could not be considered victims in the case. Although the submissions upon which this finding was made could have included more information setting out the relevant sources, they were based upon consultations with the community leaders. Second, victims group 2 challenged that trial chamber's rejection of documents containing information about the population size in relevant villages. The appeals chamber finds that having determined that it was not unreasonable for the trial chamber to reject the population size method, the documents relied upon by victims group 2 in support of the population size would have no bearing upon the estimation. Third, victims group 2 aver that the trial chamber erred by relying upon the submissions of the Trust Fund for Victims and the defense and provided insufficient reasoning, leading to the estimate that 7,500 individuals are potentially eligible beneficiaries as victims of the attacks. The appeals chamber finds that the trial chamber followed a clear methodology that involved mathematical projections from known information in the case file as well as estimates that it found within its discretion to be consistent and reliable. In relation to victims group 2 requests for more reliable figures, including through a victims mapping exercise, the appeals chamber finds no error in the manner in which the trial chamber weighed the interests at stake and exercised its discretion, while remaining mindful that its estimates must be as concrete as possible and based upon a sufficiently strong evidential basis. Ground of appeal 2. Under the second ground of appeal, victims group 2 submit 3 subgrounds. First, victims group 2 argue that the trial chamber failed to establish a proper basis for its approach to the cost to repair the harm suffered by victims of the attacks. According to victims group 2, a significantly greater number than 7,500 victims of the attacks are likely to come forward to benefit from reparations, leading, by implication, to an incorrect calculation of the cost to repair. However, since the appeals chamber rejects the arguments raised against the conclusion that 7,500 individuals are potentially eligible beneficiaries as victims of the attacks, the present subground of appeal is also rejected. Second, victims group 2 allege that the trial chamber erred in establishing the cost to repair for the victims of the attacks based upon the projections related to former child soldiers in the Lubanga case. The appeals chamber disagrees, finding that the trial chamber weighed pertinent factors in its decision to rely on the Lubanga precedent, including cost, budget, and non-discrimination. Victims Group 2 further argued that the trial chamber should have considered the Katanga Reparations Program as a benchmark for comparison, that the crimes were of a more similar nature. The Appeals Chamber notes that the findings in the Katanga case were in fact relevant to the calculations in the Lubanga case, that the trial chamber ultimately considered as part of the calculation in the present case. Moreover, Victims Group 2 submit that the harm suffered by the victims of the attacks should be addressed by way of socio-economic measures rather than mental and physical care. The Appeals Chamber finds that it was not unreasonable for the trial chamber to consider the victim's psychological and physical suffering as part of the harm to be repaired, and that socio-economic measures, including schooling support, vocational training, and income-generating activities, have been incorporated in the impugned decision. Third, Victims Group 2 submit that the established cost to repair may be fair and appropriate if 7,500 victims of the attacks come forward, but not if a significantly higher number of eligible victims come forward. The Appeals Chamber reiterates that having rejected the arguments raised by Victims Group 2 against the estimate that 7,500 individuals are potentially eligible beneficiaries as victims of the attacks, the present subground of appeal also is rejected. Under their third ground of appeal, Victims Group 2 submit that the trial chamber erred in disregarding or misapplying its previous findings on the territorial scope of the reparations. They aver that the trial chamber should have accepted victims who suffered harm in the forest or the bush surrounding the villages for which positive findings were entered in the conviction decision, whether they originated from the main villages or from any village. The Appeals Chamber notes that the trial chamber clarified in 4 decisions what it considered to be the territorial scope of reparations. These decisions all coincide in that victim must demonstrate to have suffered harm as a result of the crimes of which Mr. Ntaganda was convicted. Those who claim to have suffered harm in the forest or the bush surrounding the 13 main villages may be eligible for reparations provided that the trial chamber entered convictions based on underlying acts having occurred in the forest or the bush surrounding those locations. Contrary to the allegation of the trial chamber failed to provide proper reasoning for its conclusions rejecting specific applicants, the Appeals Chamber underlines that the trial chamber provided in a 561-page annex to the impugned decision a detailed case-by-case analysis and justification. The Appeals Chamber finds no error in the manner in which the trial chamber proceeded to apply the eligibility criteria to the victims in the sample. Accordingly, the Appeals Chamber finds that the trial chamber was not unreasonable in its findings concerning the territorial parameters of reparation and application and the application of these parameters in the impugned decision, and therefore rejects victim group's third ground of appeal. In relation to the 4 victims who could not establish their eligibility but had already received reparations as part of the initial draft implementation plan, the Appeals Chamber reiterates that the Trust Fund for Victims may provide any additional services needed under its assistance mandate. In respect of the individuals contacted by Victims Group 2 and are found to be ineligible for reparation in the impugned decision, given the limited number and the unique circumstances surrounding these proceedings, the Appeals Chamber encourages the Board of the Trust Fund to provide additional services while recognizing that the provision of the services under the Trust Fund for Victims Assistance mandate is ultimately at the discretion of its board. Furthermore, it is important to emphasize that reparations within the ICC must be viewed as part of the broader system. Not all victims of the Ituri conflict are entitled to receive reparations from Mr. Ntaganda. ICC reparations must be viewed within a wider framework that includes the Trust Fund for Victims Assistance mandate, compensation potentially offered by national legal systems, and the role of local, regional, and international organizations in implementing programs to support victims of the conflict. That concludes the summary of the judgment of the Appeals Chamber in these appeals. And I would now give the floor to Judge Ibanez, who will now present a summary of a separate opinion on ground one of the defense appeal.
Thank you, Mr. Presiding Judge. I issue this separate opinion as I find that the trial chamber committed errors of law and procedure when it issued an addendum instead of a new order for reparations. At the outset, I underlined that the appeals chamber could not have been clearer in relation to the instruction it provided to the trial chamber, leaving no room for discretion. Given the significance of the remand and the changes required, which affected virtually all essential elements of an order of reparations, the appeals chamber specifically directed the trial chamber to issue a new order for reparations. The trial chamber issued an addendum, an auxiliary document, which is contrary to the provisions of the Rome Statute, a procedural step that is not provided for in the legal framework of the court and cannot be applied to decisions that their legal nature determines substantive rights and obligations for both the defense and the victims. The only means by which a convicted person can be held accountable for reparations pursuant to the legal framework of the court is through a reparations order. When the law sets out specific proceedings, it establishes general and mandatory norms of binding character, with objective validity applied impersonally to any individual under the circumstances it defines. The judges have the duty to adhere to it without deviation. Opting for an alternative procedure under the premise that is not prohibited risks the creation of a lacune where none exists and the arbitrary affectation of due process guarantees. Non-observance of the norms and forms prescribed by the law make the procedural act null and void. Instead of issuing a new reparations order, the trial chamber integrated the impugned decision in the former largely overturned the 2021 reparations order, leaving it open to the parties to reconcile, read in conjunction, and replace parts of the different decisions at stake to discern what the order for reparations is. This course contradicted the requirement for judicial decisions to be fully reasoned and self-explanatory, meaning that their grounds and their conclusions be sufficiently clear and understandable with no need for external clarification. Certainty and clarity are at the core of judicial decision-making. They are indispensable requirements of fairness. This principle applies in particular to decisions that conclude a stage of the judicial process, as the reparations order, which decides on the parties' substantive rights and obligations. Moreover, only a clear, reasoned decision enables an understanding of the basis of a judicial determination and the exercise of the right to appeal. In turn, the appeals chamber's review can only be carried out if it is in a position to understand the trial chamber's reasoning and findings. Judgments of the appeal chamber are binding and must be complied with, as it is crucial to maintaining the authority and integrity of the judicial process. This applies in particular to those orders and instructions contained in the operative part of the judgment. When the appeals chamber confirms, reverses, or amends an order for reparations pursuant to Rule 153(1) of the rules, its decisions are of mandatory implementation. If compliance with decisions of the appeals chamber were not mandatory, its review functions would lose its purpose, and the protections enshrined as part of the court's judicial architecture would become superfluous. Therefore, in my view, and for reasons that I expand in my separate opinion, it is clear that the trial chamber made errors of law and procedure. However, upon thorough examination of the case and its concrete circumstances, and pursuant Article 83(2) of the statute, and in application of the appeals chamber's standard of review, I conclude that the errors have no material effect on the impugned decision. Indeed, even if a full and self-contained order for reparations had been issued, there would have been no substantial changes as to the 5 elements remanded for determination. I note, first, the trial chamber adequately addressed the 5 issues remanded for new determination. Second, whilst the issuance of the addendum introduced unnecessary confusion and contributed to judicial uncertainty and unreliability, the appeals chamber in the common judgment has made efforts to reconstruct the essential elements of reparations order and to establish how such reconstruction might be undertaken based on a number of cross-references. Finally, taking into account the specific nature of reparations proceedings, where other important rights must be weighed, I feel compelled to balance the procedural rights and guarantees to judicial certainty, fairness, and reliability discussed in my separate opinion against a fundamental and substantive victims' rights and entitlements to reparations and its prompt implementation. Indeed, I am convinced that any further delays in the delivery of reparations would only exacerbate the harm suffered by victims who have been waiting reparations for more than 2 decades in the case at hand. To conclude, I would like to remind that reparations are not merely acts of charity or assistance. They constitute a fundamental human right. Accordingly, I agree with my colleagues that the first ground of the defense's appeal must be rejected. Thank you.
Thank you, Judge Ibanez. That leads us to a conclusion of of this hearing today. And I should like to end by thanking all of the staff of the registry who have assisted with today's hearing. There is a lot of work that goes on behind the scenes to ensure that these hearings run smoothly, and the appeals chamber, and me including the presiding judge, is very grateful to all those involved. The hearing is adjourned.
All rise, veuillez vous lever.